of September 2016, the result of TET 2014 was published, but no merit list and scorecard was given to anyone. On 26th of September 2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that the candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. It is needless to mention, it is important, that MHRD gave relaxation only till March 2016, and in spite of that, the board notified that the candidates who do not have training will be considered too. Notification proves that the board decided to get benefit of relaxation to TET 24 qualified candidates. I shall place this notification later. Then paragraph 10 is important. Your petitioner states that after notification, the procedure was started for appointment, and from October to December, the interview and verification process started, and on 31st of January 2017, allegedly, the result was declared, but there was no panel. There was no merit list. There was no category-wise merit list. No division of numbers and or rank was given to anyone. In website of the board, there was a dedicated space where the person could see whether he or she was empaneled or not. No merit list was ever published. And in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 30th January 2017, list of trained candidates were published. On 4th February 2017, list of non-trained candidates other than the Bengali medium was published. And on 8th of February 2017, list of non-trained candidates and candidates from Bengali medium were published. From the dates and list, it is clear that all trained candidates of 2014 were appointed to the first list, and after completion of the same, as per notification dated so and so, the board appointed non-trained candidates. Then Lordship may come to paragraph 11. Just I am reading out, Lordship need not be detained for that. In paragraph 11, down the middle, it is alleged that thousands of non-trained students were appointed, and petitioners, though similarly placed, were ignored. If it is the stand of the board that no non-trained candidates can be appointed, then all appointments of non-trained candidates made after March 2016 are bad in law. Then paragraph 12. Your petitioner state that recently TET 2014 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this honorable court, the petitioners came to know that several illegal appointments have been given by depriving the petitioners. Non-trained candidates are the worst sufferers of this scam. On 23rd December 2020, the West Bengal Primary Education published one notification for recruitment of 16,500 primary teachers. And in that publication, they have stated that the candidate should possess qualification as per guidelines of NCTE. Such notification is illegal. I am just skipping over. Then Mr. Y was empaneled. A person named Mr. Y having roll number such and such was empaneled by the board. It also proves that huge corruption took place. As per the action of the board and as per the different statements given by the president of the board, Mr. So-and-so, all trained candidates were recruited, and as per the notification of the board, the petitioner should get a fair chance of recruitment, but the board has done a complete injustice to them. Then paragraph 13.
Then what was the allegation of the petitioner? 2014 was corrupted. It is your allegation.
TET 2014 corrupted, and even the selection process was.
Paragraph does not say so.
Yes.
Paragraph says that it is TET 2014 corrupted.
And then followed by, if I may, followed by they say, yes, once again, Milord, kindly come to paragraph 11. Several non-trained candidates were appointed.
Yes.
Now, the Lordship will go by the principles of a deemed pleading. I shall satisfy from authorities that the court, whose duty is to, Lord, find out the truth, should not strictly confine to the words of the pleading, but they have to also consider the deemed pleading. Here, pleading is categorical. Apart from 2014, where CBI investigation is going on, I shall also place the CBI charge sheet. Even in case of selection, non-trained candidates were appointed. Then below paragraph 12, about example given to Mr. Y. Now, this Y is relating to recruitment in 2016 selection process.
So if it is to be deemed that the 2016 process was also under, then where is the prior to that effect?
Yes. Now, may I place little more?
Just a question.
Yes. Kindly come. Let us come to the prayer of the repeat. No. It's better to satisfy the queries of the court first. Kindly come to the prayers in detail. I to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date in primary schools from date 2014, including the date of recruitment. Then direct the authorities to treat the petitioners equally with non-trained candidates who have been recruited by the board after expiry of the relaxation period.
That we understand.
Then kindly come to Milord 4.
By giving the same benefit.
5 is important. To direct the authorities to publish a merit list by maintaining full transparency regarding TET 2014 recruitment.
TET 2014, you are qualified.
Sorry, Lord, I skipped Roman 4. To recruit the petitioners by giving them same benefit by which other non-trained candidates were recruited by the board following the rules dated 22nd March 2016 and appointment notification dated 26 September 2016.
So your challenge was that either give those persons or the similar benefit like the untrained, non-trained candidates were.
My prayer is everybody is charged. To recruit the petitioners following the appointment notification dated 26 September 26, very important.
So what is the kindly address us that on the basis it seemed to us as it was argued that TET 2014 allegations are there, nothing to do with the selection.
Yes,
and that they would be satisfied in the event they are given appointment like those non-trained in the remaining.
No, but my argument would be, it might be not hurt many, that when the court finds there is institutional corruption, systematic fraud played, starting from 2014 to selection, then I shall develop that. Now, to maintain the purity of the system and keeping Article 14 and 16 in the mind, court will be non-hesitant to set aside everything and do it afresh. Now, yes. Now, I am just to complete the paragraph
12.
12. I have given the instance of Y, then 13. Your petitioner stated a candidate, namely Pulao Sarkar, was not empaneled. Another candidate named Dhiraj Bandyopadhyay, having roll number, was not empaneled. Bishwajit Burman, having roll number, was not empaneled. But they were called by the department for verification of documents, and from sources, the petitioners came to know that they were working as primary teachers. Look, this is fundamentally attack on the entire selection process. Look, how these were dealt with by the affidavit, I shall place it. Then this paragraph 13 says there was huge illegality.
Paragraph
13. Though there was huge illegality in the whole selection procedure of, it should be TET, not 2014, selection process 16, and everything happened as per the wish of the board. And for this illegality, the candidates like the petitioners could not get appointment as primary teachers. So this relates to the selection.
yes.
Then we learn a serious allegation in paragraph 15. Your petitioner further states that on 30th April, so and so, I am not naming, made a statement before the media pointing irregularities in TET panel. Recently, a person lodged a complaint against one MLA of All India so and so. That MLA took crores of money from job aspirants with a promise to give them government job in school, and in that case, personal assistant of one another MLA was arrested. The Constitutional Court would definitely not go deep into it to do complete justice and uphold the constitutional principle. Then paragraph 16. Your petitioner states that the TET 2014 examination is the biggest scam in West Bengal since 2011. Then Lordship may skip over paragraph 17. Your petitioner states that TET 2014 is the biggest scam of the education department so and so. MLA, MP, leaders of ruling party are involved, and meritorious students who qualified for the job did not get chance. And after talking to the candidates, petitioner came to know that roughly such and such amount was given for job in TET 2014. The job cannot be taken. And continuing paragraph 18, the statement is made an absolute fraud was committed by the West Bengal board by not publishing merit list in respect of, it should be without selection qualified candidates.
When you are reading Mr.
Without paragraph 18, last two lines.
Yes. Merit list of TET 2014.
Without 16, selection 6. Then kindly turn to without paragraph 22. Milord, 22, last three lines. I am not reading the entire thing. Your petitioner states that the respondents and each of them acted illegally, arbitrarily, and unconstitutionally in appointing some candidates who did not even sat for TET 2014. Serious allegation. Now, from the cans which were admitted by the court, I have prepared a list only to show that how many rank jumping was there. I shall paste that. I have given them the copy also. Now, in the background of this pleading of the writ petition, now kindly takes up the affidavit filed by the board. That is in Millard, volume 2. Page 359. Now that I would make this submission, probably it might be repetition. that an authority or institution always go by institutional memory. They do not go by individual's memory. And when an authority affirms an affidavit denying the responsibility of the previous period, it seems he admits, my lord, that there were some irregularities. I just place the language. I say that, paragraph 3. I assumed office at the President of West Bengal Board on 24th of August 2022. I was not the President of the board when 2016 recruitment process was instituted and subsequently completed. The court did not want to know that whether you are responsible, but the institution was responsible. Then from records available in my office, it is evident that in the 2016 recruitment process, marks were given by the selectors, both in interview as also in aptitude test to the candidates. I would appeal to your lordship to read between the lines. Then based on such records, I submit with utmost respect that the coherence which can be drawn thus far from such grant of marks by the selectors for aptitude test to candidates, thus far thereafter within the bracket, from such grant of marks by the selectors for aptitude test, is that such aptitude test was held. He does not positively say that from records it is apparent that the aptitude tests were held. He wants to draw an inference on the basis of what? Since marks were allotted. Then paragraph 6, he now says what steps has he taken in 2022 recruitment process. And it's interesting, my lord, would please to read. In the 2022 recruitment process, which commenced after I assumed office, the board has taken various steps which are first of its kind. Therefore, it's an admission that these measures which would have protected the selection to maintain its fairness was not there. Then the interview and aptitude test of a candidate for the 2022 recruitment process is being taken, but I am not concerned with 2022. He was supposed to answer from records about 2016. Therefore, without this affidavit, in my humble submission, Milord, clearly admits then kindly come to 363, another affidavit by the President. Here, my lord, he describes from several authorities what aptitude test mean. Kindly not troubling my lord with this huge quotation from great authorities. I am not at all interested. Kindly come to paragraph 12.
It's 325. Epidemic. 370.
The second direction contained in the order dated 24th of January 2023, passed by this Honorable Court, directs me to submit the list of interviewers at page 375.
I'm just wanting to see the 24th January order.
Yes, 24th January order, Malat, he was directed to file affidavit explaining the situation. 24th January order.
Yes.
The page 423, I am thankful to my friends.
Yes, Mr.
Yes. But the order says, in course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, The stage of interview and aptitude test came, only interview was taken and there was no aptitude test. Though in aptitude test there are 5 marks. As a large number of petitioners were present in the courtroom, I decided to exercise my power under Section 165. Oath to 7 of such candidates being so and so, so and so, this is the order.
Yes.
Yes.
Now you are showing us para 12.
Yes. The second direction contained in the order dated so and so, passed by court, directs me to submit the list of interviewers who interviewed, took the aptitude test, so and so. I say that 2016 recruitment process was a district-wise selection. 2022 the center. Now they say 2016 was district-wise selection based on the opted districts of the applicant and candidate. The interview vivabocy aptitude test was conducted at centers under the respective district primary school councils. And there is as such no distinctive record which was kept and maintained in such recruitment process, wherefrom it can be ascertained as to which interviewers took vivabocy aptitude test of a given candidate at a given center in a particular room. In 2016 recruitment rules, no method was suggested. This is the difference. Are required to be maintained by the examining body. However, a full and complete list of interviewers available with the board. Only board maintains at the center the list of the interviewers. And they don't have any record to show at all the interview was taken or not. That is admission. On the face of such a serious allegation, when the court directs to file an affidavit, not an authority who is entrusted by law to hold the examination fairly in compliance of Article 1416, files this affidavit. Now, here, my lord will not find anything about the allegations made in the petition. Maybe that this was not directed to be do so. Then kindly come to another affidavit at page 378 by Dr. Partha Karmukar. Here he deals in detail. Now that he meticulously takes the point, it's not maintainable, this and that. Because the state authorities, when takes the point of maintainability, that should really raise doubt in the minds of the court about their transparency and impartiality. Kindly turn to page 389, paragraph 9 of the, sorry, before that, I missed one paragraph. Paragraph 8. Their whole attempt is to see that the petitions are knocked out on the ground of maintainability. These issues have been considered by the court. I shall come to later. They say in paragraph 8, that Rule 6.3 is applicable to all applicants who applied in 2060 recruitment process. There is no challenge in the said petition to Rule 6.3 of the 2060 recruitment rules. But why should I challenge? I rely on this. I rely to show that 6.3 has been blatantly violated. I shall test that. Then again, paragraph 9. But if I use this term, kindly excuse me if it is not suitable. But it's a fantastic defense, paragraph 9. I say that applicable recruitment rules of 2016 made in exercise of delegated legislative power by the School Education Department, Government of West Bengal, never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup of marks, rank of candidates as contained in the petition. That this is an admission that they did not do so. They say that we have not been done. Delegated legislation does not provide us to do so. Transparency, go ahead. Article 1416, go ahead. And then further, the recruitment rules 2016 has not been challenged in the said petition. Such being the position, the answering respondents cannot be faulted not to have caused publication of the above in public domain. It's a clear admission they did not publish. However, in terms of the directions passed by the Honorable Court, the answering respondents did publish breakup of marks whom for candidates who were recommended from the 2016 recruitment process.
2022.
And that too, Milord, in terms of order dated 2022. And that's not the complete list.
Page 389.
389 to बोल रहा Milord, then paragraph 10, as I said, Milord, the defense of the recruitment authorities not to come up with records and say petition is not maintainable. I say that till paragraph 10 of the said petition, in paragraph 10 of the affidavit, the alleged grievance of the 140 petitioners were those which centered on 2016 recruitment process. In paragraph 11, the petitioners are dipped into 2020 recruitment process and made certain amendments. There is no amendment in said petition. 2020, we are not concerned. Then, in the 2020 recruitment, no untrained candidates are eligible to apply. That's not our grievance. Our grievance is 2016. Kindly come down to Milord, 3 lines from the bottom. On the date of affirmation of the said petition, I got it. 4 lines from the bottom. On the date,
Yes.
on the date of affirmation of the said petition, the petitioners are all untrained candidates who were unsuccessful in the 2016 recruitment process. In such view of the matter, the petitioners, as a matter of fact, not made out any case which calls for an interference by the Honorable Court. No denial of allegation of fraud and, all scam. Then, petitioners have failed to demonstrate existing any judicially enforceable legal right or breach in performance of any respondent legal duty warranting issuance of mandamus by this Honorable Court. It is categorically denied that the answering respondents intentionally ignored the petitioners as alleged or at all. It is categorically denied that although thousands of untrained candidates were recommended, the petitioners, though similarly placed, were ignored as alleged or at all. It is categorically denied that the relaxation given by NCT is applicable to all TET 2040 candidates who qualified TET as alleged or at all. On the contrary, it is stated that the relaxation given by the NCT applied to those applicants who applied for the recruitment process. This is a fraud on statute. I shall explain. Then Miller, kindly skip over. I am not detaining with further readings. Page 392. Well, 4 lines from the top. Unless further details. Now, now the burden is thrown upon the candidates that they have to get all details. Unless further, got it? Unless further details are furnished by the petitioners pertaining to alleged Mr. Y having roll number such and such, the answering respondents are unable to deal with such statement temporarily, reserving their right to deal with the same subsequently upon disclosure of further details. What nonsense is it? Records are with you. You are privileged with the records and you want me to produce it. Is that the law of evidence says? The answering respondent have no knowledge about the alleged different statements given by his previous president and accordingly refrain from making any comments thereon. Such refraining, it is made abundantly clear, is not an admission of the statements. The answering respondents further say that the petitioner failed to establish that there has been any pick and choose between the candidates. I have given 2-3 examples. You could have come up saying that his marks is X. We have given appointment to Y is higher than X. And now there are 100 petitions pending before this court. To summarize everything, I have just prepared below the chart of rank jumping. I shall hand over to your lordship. This is the affidavit in detail by the board. Kindly come to the paragraph 19. The specific pleadings in the writ petition when they were touched. It is stated that by the order
Page 395.
396, paragraph 19.
Yes.
It is stated by the order dated 20th December 2022, this Honorable Court directed the answering respondents to come up with the particulars in tabular form. The marks obtained by last empanel candidates of different categories and different mediums of all districts. In compliance thereof, the answering respondents bid a memo dated so and so submitted the list of petitioners along with the breakup of total score together with the breakup of total score of the last empanel candidates in the respective medium, category and district wise. The said direction was furnished in a tabular format before the Honorable Court. Such report is annexed. It is then, if upon examining the said tabular chart, further queries are required to be addressed, the answering respondents are willing to explain them. Is it not withholding? The court will direct, then only you come up with your defense. The answering respondents categorically deny that the report is absolutely bogus as alleged at all. It is clarified that if at any stage of the selection any ineligibility is detected by the examining body, then the candidature of the applicant can be rejected at any point of time. It is not a correct appreciation of the position of law that if at the time of scrutiny or verification a candidate clears his scrutiny verification, he or she cannot be declared as ineligible before or even after being recommended. In other words, if a candidate upon crossing the hurdle of scrutiny and verification is permitted to sit in the interview aptitude test, the right of the examining and recommending body to recheck, revisit the candidate eligibility is not wiped out. Any allegation against such a contention is emphatically denied. Furthermore, a candidate is rejected, the examining body is obliged to inform him the reasons, see the audacity. The reason of such rejection under the applicable statutory rules. It is categorically denied that the report filed by the examining body is absolutely bogus as alleged at all. It is further denied that the report is absolutely false as alleged at all. Well, the denial is that it's not absolutely false, partially false. The Deputy Secretary of the answering respondents complied with the order of this court. Then, my lord, will kindly come to paragraph 20. I say that not in respect of one candidate, Noor Huda Khan.
Yes.
In the present proceeding, where the prayer is for treating the writ petitioners equally with recommended non-trained candidates, the issue may not be gone into. However, if this honorable court passes a direction The alleged ambiguity pertaining to Nur Huda Khan can again be looked into by the answering respondents. It is categorically denied that intentionally marks of the petitioners were reduced while submitting the report of before this honorable court. Certain RTI query answers are cited to demonstrate that an incorrect report was submitted. Such RTI answers keep to be thoroughly scrutinized if necessary before arriving at any conclusion. But does it not show that the authority was trying to evade the responsibility? But these are the pleadings. And if your lordship really goes by this pleading, what is the outcome of it?
The relaxation.
Outcome is there has been allegations by a candidate of gross irregularities, corruption, fraud, and the authorities filing affidavit says we are answerable only when the court asks to answer, not otherwise. নোটিফিকেশনটা কবে হয়েছিল? না, একটা কথা রুলসটা
The relaxation notification.
না না রিক্রুটমেন্ট নোটিফিকেশনটা
এই recruitment notification.
ডেট কবে জানো?
26শে সেপ্টেম্বর 2016।
নাকি? Now, my lord will kindly take the trouble to come to the recruitment notification at page 120.
Pertaining to this candidate why an explanation was given, which was submitted before us. Ask your junior to just to recollect, we have taken that on record. That what is your why was it was so far as I remember, candidate why the name was not given. Subsequently, document was that submitted by Mr. Sen.
Because of the internet features, my lord, the full name was not given by the candidate.
This was a reply on their part. So please,
The full number was there.
yes.
I shall see their reply. Kindly turn to recruitment notification at page 120. The copies you may need a microscope, but
করার দরকার নেই স্যার।
the একই
না না বেটার
না।
কপি ওদেরকে দিয়েছে।
I'm just reading out, lordship may.
Only স্যার ডেটটা
This was dated 27th of September 2016. Date is important.
Page 100
20. Justice Mitra got it.
I have a better copy.
Oh,
yes,
can we note the date? Nothing else. 27th September 2016.
26
26
26. Anyway, I am not able to read it.
yes.
And this notification was issued on 26 September 2016. And let us see what was the relaxation given by the NCT for non-trained.
Page 95.
Kindly turn to page 95. Clinic থেকে দাও। সাগরদা দিয়েছে কি দিয়েছে দরকার নেই। Yes,
Relaxation was extended, Mr. Bhatt.
I'll come to that. Therefore, on that date, there was no relaxation.
On 26th.
26th of 2016, there was no relaxation. Relaxation came to an end. Kindly come to page 95.
Yes. Page 95, yes.
Yes.
Relaxation up to 31st March 2016.
Yes.
Yes, subject.
Yes. Relaxation was up to 31st March 2016. Therefore, on the date of notification, recruitment notification, the relaxation was over. Therefore, no one who was not qualified on that date could have got the benefit of relaxation. Now, I will come subsequent amendment. Therefore, on 26th of September, the relaxation granted on 9th of April 2015 had no force.
Three proviso goes.
Yes.
That's our point. I argue.
That has not been the case in the repetition.
I would again say, Milord, it's pure.
This was never a point in the
Milord, it's a pure question of law.
everything.
এটা নেওয়া হয়েছে এটা নেওয়া
Government trusted we took note of that submission. But Mr. Bhattacharya, in the writ petition, the argument which you are making is not there.
Yes.
there was no
I have read it.
Which was that line
I have read it. I just.
expiry after
Well,
expiry?
I have said that there was no relaxation. I have said so in the petition.
So relaxation, you are building that argument, Mr. Bhattacharya, with support of some element.
Yes. Kindly come to Milord the petition pleading.
Yes.
I just read out that there was.
Let Mr. Das to check it up. Proceed.
Yes, let me check. Now, what is their defense? I again say it's a pure question of law. On that date, whether the relaxation was available. What is the defense of state or the authority that there was a subsequent amendment of law? I take your lordship to that.
Mr. Bhattacharya, suppose this relaxation was not there.
The
Then
many could have not applied, considered at all.
relaxation
The para
was
90.
not there, then the 6.3 provision does not come. That is 6.3 says that you don't have the required training, you have to complete it after appointment within the specified time. 6.3
No.
has not been assailed in the
No, that 60, in deepest of respect,
correct
kindly come to 6.3.
yes, page 130.
Sir, paragraph 19 টা paragraph 9 and 19
Now, so for the first thing will answer the paragraph 9 and 19, we have said there was no relaxation.
9 and 19
If 26 September
Fact.
says, advertisement says, that is in terms of the 2nd of March rules. 2nd of March rule says that if anybody is without this training, you has to complete it within 3 months.
I'll explain that. It's not the correct.
This thing goes.
Everything goes.
Your ar-
এক মিনিট বলবো স্যার এক মিনিট এই রুলটা রিল্যাক্স পিরিয়ডের মধ্যে কিন্তু নোটিফিকেশনটা হয়েছে রিল্যাক্স পিরিয়ড এলাস হওয়ার পরে সেটা বলে দিয়েছে 2nd মার্চ রুল ফ্রেম হয়েছে 31শে মার্চ পর্যন্ত রিল্যাক্সেশন ছিল রুলটা ফ্রেম হয়েছে রিল্যাক্স পিরিয়ডে কিন্তু নোটিফিকেশনটা হয়েছে আফটার এক্সপায়ারিং দ্য রিল্যাক্সেশন
Without one explanation which comes and reasonable, that when 2016 rules was enacted, এটা কোথায় আছে দেখো
এই 2016 রুলস সেম পেজ নাম্বার 111 পেজ নাম্বার 111
immediately satisfied.
Paragraph 9,
No, paragraph 9 is pleading. That's the clear pleading.
119.
111, that's the 2016 recruitment rules.
Yes.
Kindly see, the rule was published on 2nd of March 2016.
After the relaxation according to you was what?
The rule, when the rule was made, then relaxation was available.
Yes, yes.
And that's why 6.3 was incorporated. Now kindly read 6.3.
So your contention is that after publication of rules, this relaxation was no longer there.
Yes, on the date of notification. Issue is, when you are inviting application, then there was no relaxation, valid relaxation. 6.3, which is troubling, my lord, wouldn't have troubled had this notification, my lord, and completion of recruitment process done within the period of 31st of March or 31st April, 31st March 2016. 2nd March 2016 is within the period of valid relaxation. That's why 6.3 says,
So your contention is on the date of advertisement, relaxation was not subsisting.
it's not subsisting. Therefore, the relaxed candidate wouldn't have been at all allowed to will participate at all. Now,
Including you.
maybe, well, I am one thing, my lord, when your lordship is considering the question of public employment, my lord, this is not a one-to-one issue. This is issue of, my lord, whole recruitment process being conducted, my lord, following the principles. Now, here lordship will kindly, what the state government's, my lord, stand is, as I understand, my lord, from my juniors, that there was an amendment of law in 2017. Kindly takes up that amendment. But this is a part of, I am told, compilation by one of my learned friends.
এই বইয়ে অ্যামেন্ডমেন্টটা আছে, অসুবিধা হবে। আরেকটা বই নেই? তোমাদের কারোর কাছে রাইট টু একটা বই আছে অসুবিধা? এমনি
It's not
Milord, this is very important, Milord,
23.
amendment of law, which is the probable defense of state.
আপনি এটার থেকে পড়ছেন তো, এই জিনিসটাই কোর্টে দেওয়া আছে, অন্য একজন কাউন্সিল দিয়েছিল, সেটা বলে দেবে?
কোথায় আছে?
সাগর বন্দ্যোপাধ্যায়, সাগরদা দিয়েছিল পেজ নাম্বার 1, ওটা দেওয়া।
But I am told, Milord, this is a part of the compilation filed by Mr. Shagor Bandyopadhyay.
23 was argued.
Not 23.
Kindly come to 2017 amendment of the act.
সাগর বন্দ্যোপাধ্যায় কে আছে?
এই কম্পাইলেশনের মধ্যে আছে দিনদাস।
না, এই বইটাতে আছে, এই বইটা।
আরে কম্পাইলেশন থেকে বল, এই কম্পাইলেশনটা দেখি।
জজ সাহেবরা কম্পাইলেশন থেকে সুবিধা হবে।
No, it is there with us.
Kindly, may I just place it? Lordship will immediately get it.
This section 23.
No,
No, this is the
23 section
amendment of Right to Children Pre-Education Act.
23 provides. Second pro.
Which paragraph? you are-
That it shall be deemed to have come into effect on the first day of April 2015. That is the retrospective effect given. In 2017, law is made. Retrospectivity is from first of day of April 2015, not beyond that.
Where you are reading?
But I am reading, Lord, kindly come to
পাবেন না
section 1 of the amended act.
স্যার, ওখানে পাবে না, অরিজিনাল একটা প্রিন্ট করো।
তাহলে কেন ওটা দিলে? জজ সাহেব যে বুঝতে
তাই তো বলছি, ওইটা।
ওটার এটা বের করছো।
না,
আমি সেটাই তো আপনাকে বলছি স্যার।
ওইটা কম্পাইলেশনে বার করে
ওটাই তো বার করতে বলছি আপনাকে।
What you are saying, Mr. Das?
that hoop will not really reflect that.
ওটা আপনি বলে দেন আপনার হাতে।
So may I read out for your lordship?
স্যার, না স্যার, এখান থেকে আপনার পুরো দর্শকরা।
কোনটা দেবো? এটা মার্ক করা?
ও স্যার,
কি যে করো না।
সাগরদা।
এখানে সাবলীলার কোনো আগরদা যে একটা কম্পাইলেশন দিয়েছিল, যে কম্পাইলেশনটা দিয়েছিলেন
So already keep this as your next argument.
Yes. So I'll just give the point.
You have already mentioned to us that on the date of the advertisement, there was no relaxation.
No relaxation. But the difference of state, that's why I'm pointing this.
So
State government will not, the appellant rather, have argued, I am told, that this defect was removed because of the subsequent amendment. I want to show that defect was not removed by subsequent amendment.
দেখি এটা দিয়ে দাও জজের শেয়ার, এটা একটু দেবেন। আরে ওই অ্যামেন্ডমেন্ট এবার
Kindly,
amendment.
Amendment brought on 9th of August 2017. That it shall be deemed to have come into force on the first day of April 2015. Therefore, the act was given retrospective effect vis-a-vis 1st April 2015, not beyond that. And then it says, provided further that every teacher appointed or in position as on 21st March 2015, who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right of Children Free and Compulsory Education Amendment Act 2017. Therefore, the persons who were in a position on 31st March 2015, that is the retrospectivity. Here the notification is below June 26th of September, sorry, not June.
September 26.
Therefore, the persons who were not qualified, they were not in a position as on 31st March 2015. If they were appointed, then they have to acquire qualification within 4 years.
রিল্যাক্সেশন নোটিশটা করেছেন শেষ প্যারাগ্রাফে বলা আছে ইভেন যাদের রিল্যাক্স দেওয়া হয়েছিল ওই টাইমের মধ্যে তাদের 2 বছরের মধ্যে ট্রেনিং পাবে। এই তো এই পেজ নাম্বার 99 ভলিউম 1।
Come to me that the original relaxation given at page 99.
Page 99.
Yes. That this was a notification by which relaxation was granted. And my lord will take the trouble to come to clause 7 and subclause Roman 6. The state government got it.
Page 99.
9.
It is a part of the.
Yes, but this is the, I am referring to clause 7.
Of a notification.
Yes.
First April 2020.
Right.
Yeah.
This is the first way with the Right to Education Act describes qualification.
It page. Yes, what your argument?
Kindly come to Roman 6 of clause 7.
6 years.
The state government and other school management shall ensure that teachers who are appointed under relaxed qualification norms acquire the minimum qualifications specified in NCT notification within the period of 2 years from the year of appointment. This relates to the persons who were appointed by virtue of relaxed qualification. They were mandatorily required to earn the qualification.
This is before the.
This is before. I'm just showing, therefore, relaxations are always for a particular period to ensure that the people may come up with their training qualification.
Then what happens to Rule 6? Then what?
Rule 6 becomes
There was no such.
Rule 6 becomes redundant. No prayer is called for. With notification, well, the notification is at a point of time.
So you are now challenging the rules also. Having participated, you are now challenging
I am not challenging, I am not explaining the effect of rules.
that it is a redundant provision according to you.
According to me, the notification was issued at a point of time when their relaxation was not available. Rule was made at a point of time when relaxations were available. I am trying to interpret the law in the context of the relaxation granted by the central agency. My lord will read Suks 3 at a point of time when the rule was promulgated, when relaxation was valid. They ought to have completed or ought to have invited the application within the validity period, which they did not or could not. When you publish the notice, then there is no provision for relaxation. Therefore, Rule 6.3 automatically becomes non-applicable.
Now was not there in the recruitment.
Yes,
Participated.
it was.
But they-
It was. Kindly come to Milord, paragraph 9. Milord, I have started saying, Milord, this is a constitutional court. This is not, Milord, civil dispute between two parties. Milord, kindly come to paragraph 9. I am reading out. Well, I had placed it.
Intention is when the advertisement was published, when the rule was published in March, that was in March, 2nd March 2016.
Then the relaxation period was valid till 31st of March 2016, sorry. They could have immediately invited application.
Promulgated, validity was there. Because it is within 31st.
Yes.
At the time of advertisement, there was no validity.
No validity. That's problem.
As such, 6.3 becomes redundant.
It's not applicable with that notification. I can't say redundant. If that was issued within the period, it was valid.
এখন রিক্রুটমেন্ট যেটা এখন ওই রুলেই হচ্ছে কিন্তু ওটা রিটার্ন না 2020 ফ্যামিলি 2020
Now, my lord was putting me whether there was any pleading. Yes, kindly come to my lord.
Paragraph 9, no relaxation.
Right.
9 and 19
9 and 19 both.
Yes.
And this was never dealt with in the affidavit subject to correction.
No, not deal.
Not. Now, these are the foundational facts. I don't trouble you lot anymore with facts. And I have not placed the affidavit filed by the agency. Now, the agency says, Arbu, are what করছো কেন?
Yes.
The agency says that aptitude tests and other things were done by TPSCs at the district level. That's their affidavit. Was any legal existence of DPSC then? Now, Milord, kindly see the constitution of DPSC.
রিপোর্ট আছে আপনারা পারবেন পেজ 31
So on the date of the at the time of acquisition, there was no.
Now, kindly come to Milord, chapter 6 of the Primary Education Act 1973. রসাদের দাও
দিদি
এটা লেটেস্ট তো
হ্যাঁ একদম
So kindly come to Milord section 37, the primary school councils. District primary school council, state government shall, by notification, establish for each district, excluding the hill areas and the areas included in Calcutta, with effect from such date as may be specified in the notification, a district primary school council bearing the name of the district and for the subdivision so and so. Provided the state government shall by notification establish for the subdivision of Shiliguri, I am not traveling, my lord, then a district primary school council shall consist of the following members. But all these categories are mentioned. On that date, none of these categories representation was there. What was there? Kindly come to subclause K, chairman to be appointed by the state government. Now the chairman to be appointed in a council. The chairman cannot be bereft of any council. Well, I read the K, 2K.
Chair.
37.
37 to
At the top also the chairman who shall be appointed by the state government. Now everything was done, chairman as persona. And that the existence of the primary school council was not there, has been held by this court just a few days back, and a single judgment having persuasive value. The দুটো কপি দাও সাহেবকে
পূর্ব মেদিনীপুর হাওড়া
এর আবার কপি দেওয়া
of the judgment, the detailed constitution and the methodology. Then kindly come to paragraph 28. This was the case of Purva Midnapur, but the similar is the case for all districts. But I am told Midnapur and Hooghly judgment also there. The records reveal that the district primary school council Purva Midnapur was last constituted pursuant to notification dated 21st February 2011. Its statutory tenure of 4 years expired in 2015. But no election or reconstitution of members has taken place thereafter under section 40 or 41 of the Primary Education Act. Consequently, since 2015, no legally functional council exists in the district. The same judgment will covers for Hooghly and but we have got the report of different districts. My lord may not be jumbled up with documents, but fact remains, my lord, none of these primary district school council had been reconstituted after the expiry of 4 years from the first constitution. I think Mr. Shanial Millard can enlighten if he can show that there were, at least in a particular district, This point may not be applicable for that district, but this is common everywhere. If even the affidavit which says that this is done by the district schools council is also travesty of truth. আর fact এ কিছু বলা হয়েছে? ধারা হচ্ছে শেষে। এবার judgment এ দিয়ে deemed pleading.
Yes.
Now, my lord, I shall cite authorities on few points. My lord, I was told that a thorough argument was advanced. How could the learned judge get these documents under Section 165 of the Evidence Act? Where is corruption? Well, corruption doesn't mean only the exchange of money. Corruption, my lord, means the action done in violation of rules to favor persons. That is also corruption. Now, while your lordship will be going to that, আমার তো নোটটা ছিল আর ইমপ্লয়েড নোট দা বাসে যায়
Evidence Act.
Judgment court.
Six. Seven.
Lord, I will place this in detail, a little detail, not in exhaustive, this huge judgment.
So, before you go to that, this amendment, there was an amendment to the rule itself. This that in every district primary school council it has to be published. That amendment
Centrally. Now it was amended saying it centrally it will be done. But this is not a point. They say the aptitude test and everything was done district wise. In the affidavit. I will just press it.
yes, district wise.
Therefore, district wise but by the district councils. The center doesn't say, says we don't have any record. We don't have any record of districts. We have only a list of the
Has conducted it centrally. That was the amendment.
centrally selection. Now instead of the councils, the board centrally would do. There is no quarrel with that.
Then that means that there will be no district wise interview.
Kindly come to the
Any application was made for district wise appear.
kindly come to their own affidavit. That's why please.
Concept lower.
Lord, the amendment is
That there is no existence of DPSC.
no.
Because you see this is and forget about the amendment. If the board has taken over, that means, does it mean board has taken over means all the interview district wise will go?
Lord, the board says if the board has taken over, it should be done by the board.
Where do you find that, Mr. Ortiz?
Look, kindly come to the amendment. देखिए, वो ये school को
Like, give us that
rules के amend করে primary
2016 এর rules
Rules টা
amendment
বার
করে
করো।
triple
বার করো।
triple one amendment করে বললো
বলছি
conduct
come to you.
I just kindly come to the amendment.
page 111
What is your interpretation of that?
Kindly takes up this.
Yes.
কমিটি করলো সিলেকশনের জন্য, কিন্তু অ্যাপয়েন্টমেন্ট দেওয়ার
হুম।
কথা হলো ডিপিএসসি সেখানে ডিপিএসসি
কোথায় সেটা কোথায় Will kindly turn to the 2016 rules at page 111.
Page 111.
Yes.
Sorry, we took you back to that.
No. It's very important. I should have pointed out. I missed it. Amendment টা করে কোথায় আনবো দেখা?
এইটাই অ্যামেন্ডমেন্ট রুল।
না না
না, কেন?
2016 রিক্রুটমেন্টের পরে 23শে সেপ্টেম্বর একটা অ্যামেন্ডমেন্ট হয়েছে, দ্যাট ইজ দিস। 23শে সেপ্টেম্বর
এইটা সেই amendment-টা দাও কোন পেজে আছে?
না ওটা নেই, ওটা আলাদা করে দিয়েছে, ওটা রাতুলটা আলাদা করে
That amendment is of Rule 7.
রুল 7
Let's kindly come to rule 7 first. The board shall constitute selection committee within the jurisdiction of the council with the following members. The selection committee shall normally function for a period of 2 years. Now this 7 was amended. Now similar to what is the amendment sought for? The board shall constitute selection committee for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers in primary schools within the jurisdiction of the board. Therefore, the power of council was taken over by the board.
What is your interpretation that then no counseling can be done by no committee can be constituted by respective council?
Cannot be. If the board takes over the entire selection responsibility, selection committee which was sought to be created under unamended section 7 now vanishes. And board says
The board shall constitute
yes.
unamended portion. The board shall constitute selection committee. For
Within
the
jurisdiction of the council.
just a moment. For the board will constitute selection committee for the purpose of selection and preparation of panel of such a appointed of teachers in primary school within the jurisdiction of the board.
Amended one.
Yes.
The amendment says the instead of the councils now centrally. The board-
Constitute the selection.
Yes.
But saying selection committee, there were separate selection committee for all separate districts.
Let me kindly read once again. The board shall constitute the selection committee for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers. Selection, preparation of panel is the duty of the board. In the affidavit, board say that the aptitude tests were done by district councils at the district headquarters. I just place it once again. Therefore, this really goes against their own rules. Just once again, I place it. Note. Kindly come to 375. Paragraph 12.
কনফিডেন্সিয়াল সেকশনকে দায়িত্ব দিল পিটিকা এর আগে যে এভিডেভিটটা দেখালে এখানে ওরা বলছে প্যানেল কে পাবলিশ করতে ওই কনফিডেন্স
দেখা হবে।
এটা ওই এভিডেভিটটা যেটা দিয়েছিল না
দেখা হবে। I say that, paragraph 12, I say that 2016 recruitment process was a district-wise selection.
Their affidavit you are showing.
Yes, 375, paragraph 12.
প্ল্যান কমপ্লিট অবলিগেশনস বলা হচ্ছে কোম্পানি
Yeah, we will go to
এর আগে যেটা হ্যান্ডেড ওয়ার্ক করে এটা
রাখো, এটা দেখাই, তারপর দেখা যাক।
Yes.
আর আপনি ডান দিকে তাকাচ্ছেনই না, শুধু বাম দিকে তাকাচ্ছেন। খুব বেশি পিছিয়ে আছে। স্যার, আপনার সংখ্যা
ওকে খুঁজে ওকে খুঁজে লাভ নেই। এটা উল্টো হতো না হতো তো। I say that 2016 recruitment process was a district-wise selection based on the opted district of the applicant candidate.
And where is that board was, that selection committee was done by the council?
What is that? I'm searching for that. This is the affidavit of the primary board. They say, I say that 2016 recruitment process was a district-wise selection, not centrally.
What was your reply to that? In the affidavit in reply?
But even if I did not reply, I accept this. I don't have to go file any reply to that. I say that 2016, kindly read with me.
That was not within the contemplation of these persons. Today, then suppose the hearing is taken up after 5 years. A person can argue that you should interpret my pleading as a deemed pleading construed to have included the challenge which I am arguing now.
Because what I am arguing is law. My lord, I am advancing before my lord the stand of a statutory authority.
They say that it was district-wide selection based on the opted district.
Kindly read.
Yes.
Ah.
District was, your contention is that this should be construed to be meaning that the council, individual council constituted the interview boards.
No, I didn't say that. I am mistaken. The board has, by virtue of amendment of law, the selection is now conducted by the board. Now, the board in his affidavit says, the challenge was why not the aptitude test was taken. Then the answer board says, I say that 2016 recruitment process was a district-wise selection, not central selection. Based on the opted district of the applicant candidate, the interview vibavocy aptitude test was conducted at the centers under the respective district primary school councils, and there is as such no distinctive record which is kept and maintained in such recruitment process. But if it is the central duty of a board to do it, they should have maintained the records. It is not left up to the districts. But when my lord is considering the public employment, maybe at the risk of repetition, lordship will kindly forget about the beneficiaries. My lord will be pleased to consider, my lord, the action of the statutory authorities. Because if the action of the statutory authority goes, that the beneficiaries will have no role to play.
ইন্টারভিউয়াররা বলছিল ডিএসসিতে কল পেয়েছে পেজ নাম্বার 518 ওরা ইন্টারভিউর 155 স্টেটমেন্টে ওরা বলেছিল সব ডিএসসিতে কল পেয়েছে
কোথায়
পেজ নাম্বার 518 পেজ নাম্বার 518
And third one, that this affidavit of the board would be corroborated from, kindly turn to page 518.
Please come to your reply first. Your reply is at page 391, paragraph 11.
Yes, 391. It is Oদের affidavit. 391 lot is there.
It's 391 paragraph 11.
Yeah.
Reply.
391. This is the opposition by board, not my reply. But this is detail.
You showed us page 375 paragraph 12.
Yes. This is the affidavit of board.
Yes. Now this reply to this.
No, this is not reply. That's another affidavit by board.
Yes. You have not given any reply.
No. I have placed before your lordship below the 3 consecutive affidavit by the board. I am relying on that.
Finally, reply, Mr.
Let me, yes.
Page 403.
Kindly come to Milord. 403, yes.
28 April 2023. 28 April 2023 is second debit. First one was 24 January. Page 363 it starts. Now, filed by the register affirmed.
No, my reply is at 403. May I place in detail? I did not place it because my reply does not really create any case. I have to depend on the affidavit of the state authorities. But still, then my lord is asking, I am reading it.
This year doing affidavit, Mr. Bhattacharya.
But this,
Affirmed on 28th April.
yes. This is dealing with Partha Karmakar's affidavit, the third affidavit of board.
403, my lord, the petitioner filed reply.
Yes, yes.
My
To
lord,
Partha Karmakar, third affidavit.
in opposition filed by the my lord, Dr. Partha Karmakar.
Ah.
My lord, your lordship, kindly see page 400. Kindly see page 400, affirmation section, the dual portion.
That is the reply or to Partha Karmakar.
That is the date of affirmation, 20th day of April. But by mistakenly, my lord, 403, it is written 28th April. It should be, my lord, 28th.
20th April 2022. They are writing 23.
My lord, wrongly, my lord, here is wrongly, my lord. They have done, my lord.
Affirmed on 28th of April 2023. Now kindly come to the reply. For a subparagraph A, on 7th of February 2023, the writ petition was taken up along with other 4 matters, and the Honorable Court was pleased to direct the board to come up with the breakup marks of last 10 panel candidates, district-wise, category-wise, minimum-wise, caste-wise.
We only want to see what you said about that statement.
Which statement, Milord?
That district-wise, which you pointed out, paragraph at page 375.
Will kindly come to Milord. 7. I deny and dispute the statements made in so and so. Admittedly, the petitioners did not ask for setting aside the recruitment of all candidates. It's a pair the petitioner to set aside the recruitment process, but after publication of list by the board, it is clear that law was not followed.
Paragraph 12, you have dealt with in paragraph 9.
Paragraph 9 deals with paragraph 7, 8, 9, 10, 11, 12. My lord will kindly read the affidavit and reply all pleadings in its entirety. Otherwise, lordship would not be in a position to really reach to the truth, which is the role of the court. Kindly come to Lord. May I just read it? The petitioners did not speak about aptitude test in the writ petition as they are sure about the fact that no aptitude test was ever taken up. After publication of the merit list, they came to know that marks were given in aptitude test, and accordingly, Documents were filed to show that illegalities were committed in aptitude tests, and that was never taken up. Recently, the Honorable Division Bench of this court passed one order directing the board to give 6 marks to all candidates. Is something else. Then kindly come to me, Lord, paragraph 9. The board is trying to confuse the Honorable Court. In 2016 recruitment process, no district-wise, category-wise, medium-wise, caste-wise data was published by the board. Untrained candidates were appointed and strangely less meritorious candidates were selected by depriving the petitioners. The documents submitted by the petitioners during argument prove the facts. The board did not follow their own rules, and one absolute faulty merit list was published just to cover up the wrong done by them. The petitioner state that 2020 recruitment is not our headache. Then kindly come to me, paragraph 11.
Sir, আমাদের কন্টেক্সচুয়াল সিলেকশন কমিটি ভোট করবে, কিন্তু সিভিল হচ্ছে অ্যাপয়েন্টিং অথরিটিজ দি ডিপিএসসি রুলস।
Ultimate paragraph 40.
Yes, I've said faulty merit list.
Faulty merit list was not published.
But when we come to know that somebody below the merit ranking got appointment, then we say faulty merit list. My lord, will consider a candidate. He is not supposed to know all the facts in details. He comes before the court, makes an allegation that this is a public employment, therefore this merit jumping has been conducted. Well, I have given a list, I shall give a list, which are part of the record. If one merit jumping would have caused for inquiry.
What list you have?
11/2022 in person.
Relying upon supplementary evidence.
No, not supplementary. Lord, the merit jumping, my lord, list which has been mentioned in the can, which has been admitted by your lordship. My lord was pleased to allow, my lord, some can to be admitted, and in other cases, let them argue if they want to argue. From that, my lord, I have prepared a chart showing merit jumping.
We will
Sir,
not
এটা
take
delete
it
আপনার
without checking up.
না না, আমি একদম এ দিয়ে দিয়েছি।
Can find
Yes. I have just given the detail. Lordship will get details also. I have mentioned everything.
এটা
মিটিংয়ের মধ্যে মারামারি করো না, কোনটা কোনটা যাবে।
আর এটা পাঠিয়েছি, মেলে পাঠিয়েছি।
লিস্টটা দাও, ওই তো।
অ্যানেক্স করা আছে।
These lists have been handed over to the board.
আরে একটাই
মেলে পাঠানো হয়েছে।
List of merit jumping. This is part of can which has been admitted by your lordship. I have given the detail.
আমি একটা
Can 2 and 3. Can 2 and 3.
Mr. Bharadji, come to that letter. You have received our judgments. Kindly come back.
Yes.
Anything added, Mr. Dasgupta? Don't worry. If you both of you disturb him, it will be difficult for him to argue.
Oh, the judgment দেখাচ্ছিলাম।
অ্যাপয়েন্টিং অথরিটি
দেখাবো। So this is 2006, volume 6, SCC, page 94.
94
Come to paragraph 49 onwards.
এই দুটো দিলাম। পেজ নাম্বার 804। 804 এবং ওটা না, এটা এই বলি 804
Well,
60 বলি ক্লাস ছোটটা লাস্ট ভলিউম ছোটটা।
But that was a case between two financial authorities.
Serial number, which one?
Serial number 21.
20.
Volume
Yes.
Now, like kindly 46, 47 deals with the facts little. I'm not troubling my lot with that. First. Why it may be true. First. Well, I got it.
Yes.
The relevant paragraph 70.
হ্যাঁ বলছি যখন এই টেস্ট করবো সব বলবো। Now kindly come to paragraph 44. In the absence of proper explanation, it was not open to the special court to make inferences or assumptions with regard to terms used in the documents. For example, SCB security ledger in relation to the suit bonds, which pertains to the sale and purchase of the suit bonds with different counterparties. This document as such does not contain the description portfolio. Got it?
Para 44, Mr.
Yes. Give a little bit of factual background.
Yes.
Let me read once again. In the absence of proper explanation, it was not open to the special court to make inferences or proper inferences or assumptions with regard to terms used in the documents. For example, SCB's securities ledger in relation to the suit bonds, which pertains to the sale and purchase of the suit bonds with different counterparties. This document as such does not contain the description portfolio, but the said appellation has been given to it by the special court on its own. The special court has observed thereupon. Therefore, all such transactions were entered into by the bank on behalf of HPD. Therefore, they were transactions of HPD. This is amply illustrated by Exhibit 11. A portfolio represents stock held by SCB on behalf of HPD. HPD was entitled to enter into buy transactions and sell transactions in respect of securities coming under that portfolio. The portfolio was built up by SCB by purchasing securities at the instance of HPD. This is also called as building up a position. The suit contract comes under Exhibit 11. By the suit contract, the LOA come within portfolio of HPD. He was allowed to deal with LOA under the portfolio. We are afraid that this inference is not readily available expressly from the document, nor was there any other evidence given by any witness explaining the document suggesting it. Then Lordship may skip over, kindly come to 48. While it may be true that special court has been given a certain amount of latitude in the matter of procedure, it surely cannot fly away from the established legal principles while deciding the cases before it. As to what inference arises from a document is always a matter of evidence, unless the document is self-explanatory. We do not think that any of the documents placed on record during the trial were self-explanatory, nor were they explained by any competent witness on either side. In the absence of any such explanation, it was not open to special court to come up with his own explanation and decide the fate of the suit on the basis of his inference based on such assumed explanations. In fact, these inferences run contrary to the oral evidence given by so and so. Then, Lord, we kindly come to paragraph 40. Learned Counsel for CMF also contended the SCB failed to produce relevant documents that would have established what the 15% arrangement was. For this failure, he contended that an adverse inference should be drawn against SCB. For this proposition, he relies on judgments of this court in such and such. This argument is met by learned counsel for SCB, an adverse inference is a presumption which the court is entitled to draw under Section 114 of Evidence Act, read with illustration G thereto. Mr. Jethmalani contended that the weight of the authorities would show that unless there are some special circumstances making it obligatory for a party to produce evidence, no adverse inference can be drawn unless a party has been called upon to or ordered to produce the evidence and fails to do so. Mr. Jethmalani relies upon such and such. In Hiralal case, this court reiterated the observations of the Privy Council, where the Privy Council laid down the general rule of procedure that instead of relying on the abstract doctrine of onus of proof, a party to the suit, desiring to rely upon certain state of facts, ought not to withhold from the court the written evidence in his possession. In Gopal Krishnaji, the observation was reiterated and it was observed, even if the burden of proof does not lie on a party, the court may draw an adverse inference if he withholds important documents in his possession, which can throw light on the facts at issue. It is not, in our opinion, a sound practice for those desiring to rely upon certain state of facts to withhold from the court the best evidence which is in their possession, which could throw light upon the issues in controversy and to rely upon abstract doctrine of onus of proof. In Suvanso was a situation of a fraudulent litigant basing his case on a falsehood and withholding vital documents. Merely relies on the observation made in Murugam and Gopal Krishna, both of which say that it is not a sound practice for those desiring to rely upon certain state of facts to withhold from the court the best evidence which is in their possession. On the other hand, the three authorities on which Mr. Jethmalani relied independently take the view that unless a party is called upon to produce evidence or ordered to do so by the court and fails to do so, no adverse inference can be drawn against such party. Mr. Jethmalani distinguished of the two apparently contradictory lines of authorities by pointing out that in the authorities relied on by Mr. Kapadia, the fact showed that there was a special obligation upon the party concerned to produce the relevant documents even without being called upon or ordered to do so, and that the party had failed to produce them. Further, he pointed out that observations of the Privy Council originating from Murugasam, which have been reiterated in the subsequent cases, including Citibank, would apply only if the party is desiring to rely upon a certain state of facts. He rightly contends that the 15% arrangement was neither any part of SCB's case, nor was SCB desiring to rely on the state of facts. In these circumstances, there was no obligation upon SCB to produce any documents to prove the case put forward by CMF. There was no situation in which adverse inference could be drawn against SCB. Finally, Mr. Jethmalani also asked that irrespective of what the parties did, the special court could have, if it was so minded, invoked its power under Section 165 of the Evidence Act and directed production of all documents it considered relevant, instead of relying on adverse inference which was doubtful in circumstances. This is particularly so with regard to the argument of CMF that the computer spreadsheets had not been produced as per para 7 of the written statement of CMF indicates. The CMF was aware of the existence of the such sheets and yet failed to call upon the SCB to produce it or seek an order for production of the code. The whole thrust of the impugned judgment is that the transactions between SCB and the counterparty banks, which were covered by the 15% arrangement, were sham transactions, making HPD the owner of the suit bonds. Where a transaction results in rights and obligations, it can never be treated as a sham transactions. Then, but I am not troubling with Lord Estopel. Then kindly come to me, Lord. The relevant portion, paragraph 71. Mr. Jethmalani rightly contended that when these admissions were placed on record formally, there was no objection by CMF to these admissions being taken on record, nor was there any challenge by CMF to the ruling given by the special court, overruling the framing of the aforesaid two issues. In the circumstances, he submits that it is not open to CMF to raise an objection at this stage. Apart therefrom, Mr. Jethmalani also relied on Order 12, Rule 1 of the Civil Procedure Code to contend that it is open to a party at any time to give notice by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case of any other party, This was precisely what happened during the trial. Merely because such a situation arises, the rest of the case does not get affected and has to be tried in accordance with law. In Bhagavati Prasad, while dealing with the argument that it would not be open to a party to sustain a claim on the ground which is entirely new or not pleaded, this court rejected the contention, held that it was a general doctrine which could not be applied irrespective of the facts of the case on hand, and observed thus. But I rely on this. Therefore, the pleadings, even it's not there, my lord, if it is appears from the proceedings before the court will definitely, my lord, look into this. Then para 74, with respect of that case, I am not telling, my lord. The point, therefore, my lord, which decides this court is that if something is there, some pleading is there, and parties want to rely upon, there is no problem in doing so. Finally, conclusion. Paragraph 97. Finally, it appears that there is not much to choose between the two contending banks, namely SCB and CMA. Both the banks have tarred by the same brush by Jankiram committee about fudging their accounts. However, it appears to us that the issue of ownership of the suit bonds could not have been decided on any basis other than what legal evidence showed. The situation is somewhat like a game of musical chairs. The one which is sitting on the chair when the music stops wins. Similarly, the situation before us. Once we eliminate the conjectural findings, we find that all the material evidence on record shows that SCB had purchased the suit bonds from NPCL by paying good money. The original LOA of purchasing suit bonds along with the transfer deed was handed over to SCB. As to how it went out of his possession, it appears to be subject matter of the FIR filed by the SCB so. It is pilfered or misappropriated by some officer in conspiracy with HPD, but that is a matter which will be tried by an appropriate criminal court. Turning to other side, claims, I am not placing that, that's not important. Not. The consideration was that it is not always necessary that you have to plead everything positively, but it appears to court. Evidence
এভিডেন্স তো 2022 2022 22
22 20
মামলার সময় তোমরা কি Now, the latest view of the Supreme Court not on evidence is very important. This is 2022, volume 20.
Page number 33.
Like,
page 233
Para 70.
page 233
And my lord compared page number 855.
বলেছি নিশ্চিত
This is paragraph 17 under the heading Purpose of the Evidence Act. You got it? Paragraph 17, 1-7. The purpose of the Evidence Act 1872 is to prove and disprove the existence of facts in issue and to find out the truth of the facts which are asserted by the parties, as the decision of the case lies upon and depends upon the truthfulness of those facts. The Act essentially does the balancing of interest between the parties to the proceedings, and such balancing has to be done by establishing the truth of the facts asserted. Ultimately, the Evidence Act is about the quest towards truthfulness. Procedure is the handmaid of justice and not its mistress. That is, procedure is not to control justice, but procedure is the helping hand of justice and it helps to facilitate justice. It is well established dictum of the Evidence Act that misplacing the burden of proof vitiates the judgment. At the same time, the rule relating to the burden of proof is based upon certain practical considerations of convenience and reasonableness and also policy. But where there is a rebuttable presumption of law in favor of one party, the burden of rebutting it lies upon the latter. At the same time, when any fact is specially within the knowledge of a party, the burden of proving it lies upon that party. Not I am an individual fighting against the authorities and authorities are in possession of all documents. The term especially means facts which are preeminently or exceptionally within the knowledge of a person. It is true that it cannot apply when the fact is such as to be capable of being known also by persons other than the party. This rule is an exception to the rule of burden of proof. Thus, when a person acts with some intention other than that which the character and circumstances of the act suggest, the burden of proving the intention is upon him. The bottom line of the purpose of the Evidence Act is to adopt a procedure that helps to facilitate justice. And ultimately, what is required is to unearth the truth to prevail. Now, this is the provision of law so far the Evidence Act and pleadings are concerned. Here, the sufficient pleadings are there to show that there has been huge irregularities and scam. So far, the selection of 2016 is concerned. Now, I have had referred in my pleading that there has been a CBI inquiry. I would place before your Lordship the record, the charge sheet filed by the CBI, which the court cannot be shut, not to look into it.
No date.
Charge sheet filed by CBI in jurisdictional court.
Connection with
In connection with 2016 selection, this selection which is now being considered by your Lordship, and
page number 30, page number 30. Charge sheet.
আমার লিডিং নেওয়া আছে
part of can see. Not only that, there is constitute. The ability to hear sounds and document, not the way it's placed.
now they want to shut the court. Yes, you are shutting the court. Let us go through it.
That can 22
In my petition, I have said no question of affidavit.
when was it done?
এটা রিসেন্টলি ফাইল করে
Recently, 2-3 days back. This is 2-3 days back. Investigation started then. Now, court, I again say the constitutional court cannot be put to a closure of not looking the relevant documents when the allegation is of scam.
Copy to your other side and hearing on the next day.
Next.
And other points you got.
No, therefore, no, other side is able to do. Next, kalke shunben it, porer din. No,
Mr. Majumdar, it is a charge sheet which has been filed. It is not a document out from the pocket of the very person. So he will not advance his arguments today on that.
next.
We are giving you a copy. We have not formally stated.
তোমার দায়িত্ব যে আমি এই যে করি না ভুল
তুমি যে জাজমেন্টের লিস্ট তৈরি করে তাপসদাকে পাঠিয়েছি ওটা পাঠিয়ে দিই
একদম টাইপ করা কপি
সেটা
This is 2016 recruitment process.
স্যারের প্রিন্ট নো রিক্রুটমেন্ট no
Now, why are they scared of looking at the documents?
This charge sheet is pertaining to which
2016 date, primary recruitment. 2016 primary recruitment. The all authorities are under custody.
কোর্ট অর্ডারে সেটা হয়েছে কোর্ট অর্ডার
or not rejecting that your copy, then you advance your argument.
No problem. Supply, but they have the copy because they are in the group of the accused.
বোর্ডকে একটা কপি দিয়ে এখন দেবো না এখন দেবো না
একটা সফট কপি প্রত্যেককে পাঠিয়ে
হ্যাঁ একদম বলা
আরে পাঠিয়ে দিও এখন শুনছেন জাজমেন্টের লিস্টে কোথায় আমার কপিটা কোথায়
আপনার
আরে এখানে জাজমেন্টের কপি নেই তোমার আলাদা করে লিখে-
Finally, this is a document which knows what is the big hue and cry. We are not shutting you out. Let us see, because
যে জাজমেন্টের লিখবো তোমাদের দিলাম বাইরে
that date.
দাও
If that is
একদম কোথায় গেল?
Particular, we are at the production of the document, the
তোমাদের
picture.
দিয়ে দোষ করা আছে?
short the matter.
তোমাদের নিয়ে না কাজ করা হচ্ছে ইম্পসিবল
If you, whatever you say, I shall hear, but it is a charge sheet. If it is not pertaining to date 20, the date 2014, then question is not arise.
He could have got many other documents, we were restricted by the law.
Mr. Laidi, we have heard all of you extensively.
আমরা
We cannot shut him down. Let him complete his arguments. Allow us to proceed.
Does not have any reference to this.
Mr. Banerjee, Mr. Mojumdar, you're getting an opportunity to come and tell us that. Yes,
Yes. Now, my lord, I now take the lordship, my lord, the corruption, the Supreme Court says, তোমার তো আছে বাবা তোমার তোমার লোকের তো জেলে আছে
Party, কেউ জেলে নেই।
2000 ওটা কি এখন দিচ্ছ কেন সফট কপি পাঠিয়ে দিও
সবই দিতে পারবো না।
এত হাত দেওয়া যাবে না।
স্যার এটা সার্টিফাইড কপিও তো নয় স্যার আপনি মানে এটা
দেবে তোকে সফট কপি দিয়ে দেবে বাড়ি থেকে পড়ে এসো যাতে তোমাকে জেলে যেতে হয়
স্যার ওরা সফট
তাহলে I am not the Supreme Court, not what the Supreme Court says on corruption.
Bhattacharya, give them one hard copy, they shall share it.
Yes, if you share it, you get it.
And you send
Yes.
it to all of them.
দিয়ে দাও
এটা দুটো জাজেস কপি
Just now today,
চার্জেস কপি বাদ দিয়ে অন্য কপি থাকলে দাও না থাকলে পরে দিয়ে দিও
কপি দুটো জাজেস কপি
yes, Mr.
তাহলে পরে দিয়ে দিচ্ছি আমি সব কপি তোমাকে এক্ষুনি আর ড্রপ করতে
আরে হার্ড কপি দাও একটা আগে।
Yes.
Now, will kindly come to below 2013 3 SCC, page 1. আমার বই কোথায়? ছেড়ে দিয়ে না 2013 3 SCC.
Can we suggest one thing? So far as the judgments which you are referring to, tell us which judgments, we will go through the judgments and we will go
Lord, I have the,
cut short.
yes,
For your advantage also.
my lord. Lord, I have given the detail, my lord, in the compilation.
There are,
In,
how many judgments we will read. If you
Lord, at least, my lord, 10, 12 judgments I have to cite.
just tell us those judgments, we shall.
If your lordship permits me to cite the recent division the judgment of this court, which was upheld by the Supreme Court in SSC, I think that covers all these judgments.
That has been given to us.
Yes, Lord, we can, Lord, place that, the lordship find all these judgments, Lord.
That is entirely do not place, that is a 400-page judgment. It will not be.
The principles, I will just, Lord, say the principles.
So what you give us the citations which upon which you will be placing the.
Yes, Lord, kindly, চারটা দিয়েছেন
দিয়ে দেওয়া দেওয়া
There are 3 compilations. Which, the 3 volumes. Have mercy on us.
তোমাদেরকে একটা
Total
দিয়েছিলাম কি জানো?
Judgments you are.
Total 23 judgment in 3 volume and the index is there. In first volume index is there. Kindly take the first volume.
কোথায় ভালো?
That is index. So index.
তোমাদেরকে দিলাম লিস্ট করে আমি জানি না তোমরা কাজের সময় কেউ থাকবে না।
Where are the paragraph numbers?
এতে কিছুই নেই
কিছুগুলোতে লিখেছে কিছুগুলোতে লিখে
But we don't have the references, at least let us have a copy. দাও কপি দাও কিছুই তো জানি না কি দেখা
Now, I just not indicate not what I'll rely upon.
You have already relied upon 2022 volume 20 SCC
Yes.
and 2006 volume 6 SCC 90.
Now, Lord, I shall Immediately place 2013 3 SCC, page 1.
2013,
3 SCC, item 3 of the.
which paragraphs? 92, 93, 95.
No, but I have to check it not while placing.
That is given in violation.
Hmm.
Serial number 3.
Yes, kindly turn to এখানে কি করেছো না? Yes, kindly, my lord, this is very important, my lord. So for the role of
2013, volume 3, SCC 1.
page 1, the corruption and the role of the court and authorities.
You are placing para 90.
Two, para 92. That at page, this is page 218 of the compilation. Compilation কোন volume দিয়েছে আবার? Index করে দাও যথাযথ।
সেম ইন্ডেক্স
First volume, page 218. এখানে 170 ওটা শুরু হচ্ছে। Paragraph 92 টা 218 আছে।
This is unfair. তোমাকে বারবার লিস্ট করে দিলাম তো সেই লিস্ট তুমি কেন দিলাম? This is
জিজ্ঞেস করছে কি বললো যে আমি চলুক
তুমি হাতে রাখবে।
Request you summarize your argument, what you have submitted before us, and give us the judgments which we will take it from Mr. Ram.
I shall indicate. Well, not Mr. Those who have not been in a position to do that. I shall.
Please summarize your argument.
My argument is very short.
Yes.
That a selection process initiated by a public body has to be above board beyond question. Any infraction would vitiate everything. Otherwise, people will lose confidence in the entire system. And corruption would become a part of machinery which will destroy the democratic process.
Yes.
The court's outlook with regard to the public employments, if it is, even in one or two cases, if it is found that it was in violation of statute, Supreme Court, even after a continuance of 20 years, said, no, you go. Many judgments went up from our court also. I shall refer those judgments. There is no scope for any compassion or sympathy for illegal recruitment. But this is the basic thing. Now, before I conclude today, oh, it's over. I just will not rely this judgment We're placing below the paragraph 92, then conclude today. Corruption in a civilized society,
Paragraph
92, 92,
at page 218.
18.
Yes.
But before I start this, admitted position, the court have to take judicial notice of the fact that there has been criminal investigation related to this recruitment, and in prima facie, the persons have been taken into custody and charge sheet have been filed, which proves the corruption. And that's the criminal part of it. When it comes to the question of constitutional court's intervention, then we'll have the basic principle of Article 14, 16.
So what is the date 2014 was included within that, or it was part of the
2016 recruitment.
2016 date?
That's a date and 2016 to include.
No, but I would stand correct after placing.
Pertaining to this 26 September 2016 advertisement
Right. sir. And
of 92.
the corruption in a civilized society is a disease like cancer, which, if not detected in time, is sure to spread its malignance among the polity of the country, leading to disastrous consequences. Therefore, it is often described as royal thievery. Corruption is opposed to democracy and social order, as being not only anti-people, but also due to the fact that it affects the economy of a country and destroys its cultural heritage. It poses a threat to the concept of constitutional governance, which pricks me more, and shakes the very foundation of democracy and the rule of law. It threatens the security of the societies, undermining ethical values and justice, jeopardizing sustainable development. Corruption devalues human rights, chokes development, and corrodes the moral fabric of the society. It causes considerable damage to national economy, national interest, and the image of the country. Now, the basic index of human development is education and health. But if the education is vitiated with any sort of corrupt practice, it really chokes the development of ethical values and sense of justice. আজকে না সবই আজকে হবে নাকি Now, may I stop it today? Deeply. Next day, I shall just take the other judgments and conclude.
Because who is appearing for the, so what is it? For
Appearance given.
yes, please.
আমাদের
Appearance সবাই দিতে হবে।
এটা আমার মার্ক করে তোমার কাছে রাখো, দুটো তোমার কাছে রাখো, উপরে লিখে রাখো বিআরবি বলে। This is the list that I would basically the Lordship may take into consideration not, but this is the chart of rank jumping, which will appear from the pleadings.
Given to the board.
Because we don't
But they are,
that
yes, but their opposition doesn't matter to me. It has to be opposed by the board.
nobody.
ওরা চিৎকার করছে, ওরা ইচ্ছা করে।
Well, there are cans for the TET who didn't pass the TET also.
আমাদের কেউ নেই নো হ্যার ইন আমার
যদি ওপেন করতে হয়, সব ওপেন হয়ে যায়।
সব ওপেন করে দেয়। হ্যাঁ
on the next date, we also can come up with
I shall just hand it over chart to
three volumes have been given.
the judgments.
you can only
just indicate below the cases.
only you be facing all the
No, may not be. May not be.
possible. Sir, what is it to point out?
Here and now. Here and now. Should be. Here and now. देखिए list कोথায়? এটা প্রেস করেছি।
It's a Wednesday. We are reopening on 27th, 24th. There are intervening 25, 29th at 2 p.m. We are keeping. Yes. No, Mr. Shall get.
কম্পাইলেশনটা কি মার্ক করি
এটা সেম সেম
না না এইগুলো ঠিক
আপনি বলে দেন স্যার এন্ট্রি
Space. Please keep it with you because 44 files are there. Keep it with you and remind us when you will be here. If he contacts there, after that we can. Yes, Mr.
I will just indicate me that. May I just indicate in your
Sir,
ঠিক মেরে দাও এগুলো।
1 থেকে 4 6 থেকে 10 আর ওই শেষের
ওই শুরুটা হ্যাঁ
সরু প্রথম পেজটা
খুব এটা কিন্তু কোর্টের ব্রিফ সেভাবে
ওগুলো দশের শুরুগুলো
only one
এই কটা ঠিক মারো।
have considered that small qualification.
এটা এক
না না এখানে অন্য জাজমেন্ট আছে
You have already given us 2006.
2 3 4 6 8 9 10
বললেই তো আমরা চুকে নি বিকাশ দা
আর 11 ব্যাস।
ও বিকাশ দা বলুন না আমরা লিখে নি
হ্যাঁ ও বলে দিচ্ছে তোকে দাঁড়া
স্যার এটা সেকেন্ড জাজেস করে
করে দাও।
Reading that number 2 from which this compilation?
Yes, well, I'm reading that to the compilation of your lordship, which was handed out to your lordship,
দুটো আলাদা
volume 1.
Down.
আর এগুলো দরকার না।
এটা তারা 21 ইমপ্লয়েড প্লিডিং
ও এটা দেখানো হয়ে গেছে 22
আর 22 এটা
ব্যাস
আর এটা সেকেন্ড জাজ
একই জিনিস তো ঠিক মেরে দাও।
এটা বলে
তাহলে দেখে দেখে টিপ মারো
ঠিক আছে
দুটো তো মিলে
ওকে ঠিক আছে
এটা সেকেন্ড জাজে
সেকেন্ড জাজ
এই দেখো ছবি তো
Yes, that
3
6
4 8
একজনকেও ছবি তুলে নিজেদের এতে নিয়ে পিক মারা গুলো
লাগিয়ে দিন
এতে কোনো ঠিক মারিস নি এগুলো সব এতগুলো দিয়েছিস
এইটাই তো বোঝ হয় এই তো কটা আছে এখানে 12 এইটাই তো
এর 22
ব্যাস আর এইটা 2006
বিকাশ দা পরের পেজে আবার দাগ দিচ্ছেন নাকি
দুটো ওই যে ইমপ্লয়েড প্লিডিং
আরে যেটা অলরেডি রেফার করে দিই
এটা ইন্টেলেকচুয়াল প্রপার্টি রাইট বুঝছিস দিয়ে দাও।
কোনটা কোনটা পরের পেজে গুলো দাগ নাই
এই যে না 21 আর 22 যেটা দেখাবো
we are declaring this item.
এটা কার
তো এটা আপনার কপি আপনার
এটা তোমার কাছে কমেডি
You have tick marked all the judgments.
no out of 23 only entry number
10, 10.
2 3 4 6 8
Joseph
9
is-
10 11
the 3 judgments already been cited.
and 21 and 22 11
একই আছে
এটা পরে পেজে আছে
Oh, well.
আমি told both the juniors of Mr. Bhattacharya citing different judgments so it compile
no
right hand side one
no
আমি কি
Actually, take it down. 2012 volume 3 SCC.
লেখ
2012 volume 3 SCC 619.